Good morning, outside world. Welcome to something that is not a law office, but it is Ask a Lawyer. Was that really cheesy? I have a feeling it was. I'm not an intellectual property lawyer. I have a superficial understanding, and I have a lawyer's training and ability to read the statutes and understand some of the concepts. A lot of lay people can do that. Some of you may think everything I'm saying is old hat, and you know it perfectly already. That's perfectly acceptable. The problem is there's a lot of people out there that think they know, and hopefully I can stop some of the think they knows from making things worse on themselves or for giving bad information. So now I'm going to have a couple disclaimer screens up that clarify I'm not offering you legal advice, I am not your attorney, and if I'm wrong, relying on me is your fault. There's two schemes that protect people's intellectual property in the United States. If you're watching this from somewhere else, your rules are going to be different. They may be fairly similar because most developed countries follow what's known as the Berne Convention. It's an international treaty on copyright, but I'm talking about the U.S. So in the U.S., copyright deals with the creator's rights that come from creating whatever's being created. How's that for a lawyerly definition? It would make my English teachers cry. When you create something, you have the exclusive right to decide when and how that is used. That's the copyright series of rights, and it's much more complex. There's a whole series of sub-rights that are involved in that. Trademark is a completely separate statutory scheme of rights. Protections that come from registration of the mark. It's a mark that identifies or is linked to your business. So it's an image, a font, a descriptor. It's something that identifies the work. Quick review. Copyright vested in the creator based on their right to say who gets to use it because they created it. Trademark, statutory right as well, based on image, font, anything that identifies the business. Initial question I was asked is, what's in the public domain? Which is basically what's not protected. What is not covered by copyright or trademark? And it's a very complex answer. There's a lot of different categories depending on when something was created, when the creator may or may not have renewed. The main thing for creators and makers to think of here is that anything created after 1978, the mere act of creation vests copyright rights in the creator, in the maker. Prior to 1978, there was some confusion about when a notice was used or wasn't used or how it was registered or not registered. That ended. With the statute, it created time period. For an individual creator, the copyright is life plus 70 years. For a corporate creator, it's the shorter period of 95 years from publication or 120 years from creation. To boil that down to something that does involve a lot of numbers, anything you're interested in making that the kids are into these days is probably recent enough that it's going to be copyright protected. What about fan art? What if I'm drawing my own Jasmine and Aladdin? What if I'm reshaping the NFL logo? There's still a violation there. The first part is the copyright holder, it's an exclusive right. Use of that in any way, unless it's one of a very few statutory exceptions, it's protected. They own the right to exclusive use of their intellectual property. This also ties into trademark because most logos, character designs, character color schemes, the green tractor with the yellow wheels, those are trademarked as well. So if you're creating fan art or fan fiction or fan designs or anything, to boil it down to the practical, It's sometimes a question of scope and dollars. If you're creating Harry Potter fan fiction on a site for Harry Potter fan fiction, more often than not, they're going to let that go. It's just seen as a hobby, as a way for fans to express themselves. It's not a commercial venture. It's not a attempt to profit from their or her intellectual property. In other cases, some copyright and trademark holders are more aggressive. Any attempt to use their characters or their image or anything is met with a notice. Short, practical takeaway is any use of someone else's copyrighted or trademark material is technically infringement. A lot of times they let it slide. One thing I've learned is that most takedown notices and most problems with infringement don't come from Disney or Searchlight Pictures or any other big company searching the web for your Mickey Mouse pillows. They come from other sellers who are trying to knock you out of the market. It seems to be what I've learned on that. It's a sad commentary on humanity, I suppose, but aren't they all? You're taking your risks if you're using anyone else's material other than your own. Now, I did mention a couple narrow exceptions. Whatever someone on the street tells you they are, they're probably wrong. The couple narrow exemptions are parody and basically educational use. A lot of things I hear like, I drew my own version or I changed it, those are derivative works which are protected by the copyright law and are technically infringement. But what happens when you infringe? The next and the final question. It's a uncertain answer because everything involving lawyers is always uncertain. The common thing that happens these days through the Digital Millennium Copyright Act is because most people are selling their wares through some kind of online portal. There's a well-worn path between the copyright holders' lawyers and the offices of the online vendor. They'll usually issue a notice under the DMCA to the vendor, which gets the listing pulled or frozen. The seller then has time to respond. There's a whole statutory scheme that ends with a potential lawsuit if the parties can't resolve whether or not. But apart from the parties, if there's a suggestion of infringement, usually it's pulled from the website and that product's not up for sale until the matter's resolved. They're going to start with notices, either to Etsy or eBay or to you, or they're going to send you a cease and desist letter on their lawyer stationery. Those are usually good to read very carefully and discuss with your lawyer if you have one. There are cases that say the company's not always right, but these seem to be narrow exceptions because a lot of makers and creators are using material belonging to other people, and a lot of times they know it and they just do it until they get dinged and then it stops. So if you're one of those people, realize you're getting away with it right now, and at any point that letter could show up that says you're using our property. Stop. So there's a couple quick things on copyright, trademark, intellectual property, fan art, whatever else I talked about. I've forgotten it already. It's a Swiss cheese in here. So I hope that explains a couple things about copyright for you that are helpful in your online business or your creative efforts, your artisan work. If you have any questions, I'm not going to say comment in the comments because I can't give legal advice in a video. I'm going to say talk to a lawyer in your community. Shop local, even with lawyers.